just to give you a little bit of history here, back in 2002, which, in terms of social media and in terms of the internet, is kind of like light years ago, there was a case where a court actually said, you can serve process by email. And this was kind of novel at the time, that, you could serve someone with a summons and complaint using email rather than a traditional means of personal service or service by registered mail and things like that. But realized that all of those things had been tried first, and the court probably would not have allowed this unless they had tried all those other methods first and failed. So we fast forward 10 years, 2012, and we have the first reported case where someone is trying to serve process by Facebook. And I'll talk about both of these cases, and they're only a year apart, and they're in the same court with different judges, but still both in the federal court in New York. Now, in the first case, there was an individual who sued a bank claiming wrongful garnishment of her account. The bank then realizes that the woman's daughter had engaged in some activity, and they wanted to bring her in as a third-party defendant. Well, they couldn't find her. And one of their investigators did a search and found someone with that name on Facebook. So they go to the court and they say, we found her on Facebook. Can we just serve her on Facebook? And the court said, no, that's really not reliable, because anybody can open an account in anybody else's name. So they said it's not reliable. We can't assume that that's her. And we're not going to let you serve her through Facebook. Now, the other interesting thing there is they did say, but instead you can publish it in the New York Times and you can publish it in her local newspaper where she last lived, and we'll let that count as substituted service instead of service by Facebook. Now, what I find funny about that is that if she's under 30 years old, the likelihood of her reading a newspaper compared to going on Facebook is so much more remote. Whether that was, I think it would have been a lot more effective. The service would have been a lot more effective through Facebook than through the newspaper publications. Okay, so then 1 year later, we have a case where the FTC is trying to serve an Indian corporation and individuals in India. Now, why were they going after them? They were going after them because they were claiming that this company and these individuals were targeting individuals on using computers and saying, oh, you have a virus here, you need to buy this and it'll fix it. So they were saying that there was some fraudulent activity around trying to convince people that they had some issue and that they needed to fix it. Well, the FTC did go through the proper procedures. When you're dealing with somebody in another country, you're supposed to go through what's the Hague Convention procedures, and they did do that. They tried to go to the agency in India that is responsible for delivering the service of process. Well, it didn't work. The agency there just sat on it for 3 months. They ignored the FTC. So the FTC goes back to court and says, look, we need to serve them, and we know they have this Facebook account because there had been some earlier communications with them through Facebook. So the court there did allow it. So I think it's easy to reconcile these two cases, because in the one case, you have a bank trying to serve an individual that they don't know for sure if that's that person's account. And in the other case, you've got a federal agency who is trying to, protect consumers and dealing with somebody in another country. So I think that's how you can reconcile these cases.